can we think about priorities and get pipelines and roads done first? Just really focus on that. It's so important.
I guess I'm not understanding what the advantage is of waiting on the moratorium.
I don't think anybody picked up on it. Sorry.
Oh.
Anybody picked up on your reset the time clock, then I think that's what it is.
Can't hear a second.
Since the clock is running on a big plate of items here, perhaps it would be better to focus on the things that we have in our tool belt right now to do, and save the clock starting on a moratorium for the other items that we need the moratorium.
Yeah, well, we're not discussing that. We have a question and you get the answer, not to-do list. So why can't you keep it in focus? What is your question?
My question is about priorities. Can we take the two things?
Well, ask the town board.
So Don, maybe you can
What is our priority?
I'm not sure that that's a legal question, but to the extent it might be, I think whether or not a moratorium is appropriate to deal with any of those issues, one or more of them, is a legislative decision for the town board. I think that is what you as board members are going to need to debate with input from the community. The only thing I think everything on that list is either wholly or partially within town jurisdiction. Some of the problems that are going to come up is how long it may take to identify and map an aquifer, how long it may take to put in place a road use agreement, how long anyone in a matter of, you couldn't really find a CEA or a wetland easily right now. A lot of the plants don't exist. You'd have to wait till spring or early summer to do that. But let's say within a reasonable period of time, 6 months, you could identify all these areas that you believe qualify as CEAs. As I sit here right now, to create a CEA requires the approval of the DEC. They have to approve it. You have to prove it meets the qualifications, then they map it, and then it achieves a special type of protection, special designation as an important ecological resource of the state of New York. How long that administrative process takes, once you have all your data in hand and the DEC processes and maps it, that's an open question. So while the identification and application process for a CEA are wholly within the jurisdiction and power of the town, actually going through the process and having the DEC agree it's a CEA and map it, or having the DEC determine whether you are in fact dealing with a secondary, a primary, or a sole source aquifer, those are administrative processes that involve the state that don't necessarily have known timetables. But I think everything on that list is within the authority of the town. The only possible exception is the question of bans or partial bans, and that's a legal question that has reasonable arguments, at least legally speaking, on both sides, and the courts are looking at that now. So to the extent that there's a legal question there, I'm not sure it's a legal question, but I think your question gets to the heart of what the town board should be deliberating, weighing, and deciding upon.
Can I try to interpret? Is your question, what's the strategic advantage to doing the moratorium now as opposed to, say, 6 months from now?
Well, if we cut the list down on things that we can do now, and Guy brought up a point I hadn't thought about, seasonality. So, get the road and the pipeline piece done, right now, the first 2 quarters of this year. And then...
I would like that question answered, though, that you raised. I would like that.
Sure. So the question would be that I thought I heard in Linda's comment. The question was, is there an advantage or disadvantage on the timing issue of having a moratorium now or passing a moratorium 6 months from now? Is there an advantage to doing the moratorium now? And I think that's more of a legislative, or maybe it's a legal question.
Yeah, I think it is a legislative thing that has to be weighed and balanced, because there's obviously cost and risk to doing something, and there's cost and risk to doing nothing, and those are the two sides that you have to weigh out as to what's in the best interest of the town and its constituents. But the issue with a moratorium or not having a moratorium, this is a question that's coming up in a lot of towns. Enfield's looking at it right now. Lansing's looking at it right now. Obviously Caroline is. Genoa's looking at it right now. Summer Hill's looking at it right now. There's a lot of towns all over the area that are looking at this question, and this is a very common question asked. To the extent there's a legal answer to it, it has to do with what happens when a permit issues. Normally, in order to achieve what you would call a grandfather right, which is basically a way of attaching the concept of no ex post facto laws. If you're familiar with that constitutional term, it means you can't declare something illegal after it's already done. It's either a crime or it isn't. So what grandfather rights is making sure that a change in zoning or a change in land use or a change in law doesn't prevent what was prior to that moment a proper use of property. Common in zoning, we're going to change this zoning designation, and this is going to all be a residential right now, but this little mini mart, it has grandfather rights and it can stay there for however long it wants, and there are a lot of rules about that. So mining is different, and I'm not talking about gas mining, I'm talking about all types of mining in New York State, because grandfather rights, let's say in relation to a building permit, attach when you have what's called a substantial investment in the ground. You can't really have an idea that you want to do something and maybe a sketch somewhere. You need a building permit. You need to have put enough investment into it such that it has the equivalent of a property right attached to it. And the mining process, whether you want to mine gravel or natural gas in New York State, is deemed complicated and expensive enough that the mere obtaining of the permit is in itself deemed the equivalent of a property right and gives grandfather rights. So, if the permit is issued and you at a later point pass a moratorium, it really will have no effect whatsoever on that permit. That permit will have rights that attach to it. And that may or may not be an issue for your board depending upon how this town and its citizens feel about the issues and impacts that may arise from this process or this industry. I think if you take a look at road use, and that's an area where everyone knows there's authority to act and where everybody reasonably realizes there are going to be significant impacts if there are drills in the town or even near the town where they're passing through. Trying to put a road use regulation into effect after the damage has occurred is a little bit like trying to push water uphill. It's a difficult thing to do because if you've ever tried to foreclose a road guarantee or a road bond, you probably would have some knowledge on how difficult these things are to enforce. You need to have your groundwork done. You need to know what you're dealing with. You need to document a number of things about your road. You need to understand not just how it's built, what type of traffic it normally conveys, and how it may be impacted by an increase in a particular type of traffic, but what about simpler questions? What about overhead wires and road geometry? How does certain trucks this size make it through certain intersections? If that kind of stuff isn't looked at in advance, it may be too late if it comes later. New York State has attempted to try to work around that by, in ECL 2303 subdivision, I think it's 4 or 5, to create a fund to deal with road repairs and road upgrades for municipalities that are damaged by this process. Great idea. The problem is there's not a penny in it, and there never has been. So really, this is for lack of a better term, a form of unfunded mandate that's being passed down to counties and towns, and the question is how do you deal with it? So because it's a property right, if you were then trying to stop it, once the permit issues, if you then try to stop it, it's not like saying you can't have a commercial industry here, or you can't have a processing plant here, or you can't have an iron smelter here. You're dealing with, by then, what is a grandfathered property right. If you take it away, the question of whether you can and what the damages associated with doing so are increased exponentially. The risk goes up. So that's the little legal snapshot of whether there is increased risk doing this before or after a moratorium. And whether that risk is in the balance to the town board and its citizens, going to make them add to or decrease from that list, that's a legislative judgment.
Just a quick follow-up. So I heard in that there may be a risk if permits are issued before we do a moratorium. Is there any risk from passing a moratorium now and having it run out after a year and say risk not getting what is on our list to consider? Does that put the town at risk too?
One, if you haven't, diligently pursued your goals, then yes, you might not be in a position where you could extend the moratorium if there was a reasonable basis to do so. Two, the longer a moratorium lasts, the less likely it is to survive a challenge. And like I said, that depends on the good faith efforts of the agency that set forth the moratorium. It's not always in New York governments that do it. There are public authorities that can do it, transportation authorities, thruway authorities that can put moratoriums on things as well. But and two is how complex is the subject matter. So if you're dealing with going out and doing field studies on known potential wetland locations, it's not, wetlands aren't just, oh, there's cattails. You're using indicator species to identify an ecosystem, not just identifying land that is wet. There's a distinction, and New York State will make you prove it. If you know where they all are and you just haven't done your delineation studies and you let the spring, summer, and fall pass and blew it off, chances are you're not going to be able to extend on the basis of wetlands, even though, in fact, you might have needed to had you done the delineation studies. You have to go through the process. So it's important to know what you can accomplish in a year and understand and make sure the public knows what pieces you may not be able to accomplish in a year despite due diligence, so people can weigh, well, what if somebody's opinion might change whether this lasts a year or whether this lasts 3 years. So understanding what kind of time frame, building out some kind of timetable and action plan so you can identify how you're going to tackle these different projects is probably important. But for aquifers, it would be highly unlikely you could map and get all your aquifer and recharge data in a year. You've got to get test wells in, you've got to study seasonal variations in test wells. Yeah, that's good. Then you're ahead of the curve, because some towns have not even started that, and they're saying, can we do it in a year? I'm like, how much money do you want to throw at it? It's possible, but not likely. So they can be extended. It's perfectly legal to extend them. There is one case in New York where a moratorium had lasted 8 years. There's a number that have survived 3 to 5 years, but a general rule of thumb is the farther you go from 18 months, the less likely you are to survive.
Are there any yes buts to this conversation, or should we move on to the next stack of people?
I had just one follow-up question for you. Question was, you spoke of something about grandfather and whether or not that they had monies invested enough to consider it to be a grandfathered clause. Well, some of the people have had a lease for 4 or 5 years now. And so these gas companies are going to say they've got a vested interest in this town. Why wouldn't the people that have gas lease be under a grandfather of this moratorium?
Because the law, I'm not saying the law won't change, but the law generally recognizes the issuance of the permit itself as the triggering event. For example, if I were to lease up half of the town, get lease rights to put in 5-story apartment buildings, would I have a grandfathered right to put up 5-story apartment buildings? Well, no, not until I got the permit and put a substantial investment in the ground. That may be a ridiculous example because nobody's going to spend money on leases for apartment buildings.
Would the investment of the lease that they gave the landowners be an investment?
I'm sure that's an argument that will be judicially determined if it comes up, but the current state of the law is it's the actual issuance of the permit that triggers it, because the permit is considered by definition highly speculative. You do not know, even if you have spent all the money in the world, whether or not the DEC or the EPA are going to give you a permit for anything. Many a hydroelectric dam has had millions and millions of dollars spent on getting the rights and the engineering and never got the permit. They didn't get rights to put up a dam merely because they spent the money. So